Hello and welcome to this very special segment. Joining us here today is none other than Justice Hrishikesh Roy, speaking to us one day after demitting office. Sir, appreciate you joining us. Thank you so much for taking the time out. It's your first morning post demitting office. How does it feel?
Well, the one difference that I can certainly mention is that yesterday evening, those 60, 70 files from the Supreme Court registry has not come. Normally, those files will be staring at you either in the physical form or in the digital form. Those are not there.
Yeah.
But then, as is habit for last so many years, I had gone early morning to the office, sat there. Of course, there are always correspondence to attend to. So as is the habit, I had gone in the morning to the office. Not that I just stayed in my room or in the drawing room or lingering in the dining room. Not like that.
So yesterday we heard you talk about how you came to Delhi for your education, holding your father's hand. How has your journey been till now? What are the challenges that you faced as a Supreme Court judge, and how did you manage to navigate through them?
Well, you remind me of the time of 1971 is the year when I came to Delhi. And as you described, holding my father's hand. It must have been like that only because I was studying in a vernacular medium school in a rural Assam place called Borpeta. And then my father thought that perhaps, because I don't know, somehow I thought I'd become a lawyer, although I don't know what prompted me to think like that. But he thought that an education in a English medium school or a good school would do me good. So there was a system of the Union Education Ministry of All India Merit Scholarship. I qualified in that examination. And then you get admission to various public schools which are in the roster of the ministry. And of course, my dad, we call him Deuta in Assamese. So Deuta thought that, all right, so many school options are available, but then if I can have a school in Delhi, that would be better. So that's how I landed up in Delhi Public School. And since I didn't know any English nor any Hindi, just after passing class 6, so I would say the early days were a little traumatic because you just don't know what is coming, and I couldn't follow most of the things that the classmates used to say. But the journey from then onwards, I've had some very wonderful teachers in school, particularly my English teacher, Sri B. Das, I still remember him very fondly. And my friends, some of them were very, very helpful, looking at the plight of this boy coming from Assam, not knowing Hindi. For instance, in Hindi you say pina, right?
Yeah.
But in Assamese, khana and pina is same.
Okay.
Like you say, water khayenge, in Assamese if you have to say.
Okay.
So one day I sort of said to my friend Rajiv Barwa, chalo, Coca-Cola khane chalte hain. So the entire boys and girls who were near me, they practically burst into laughter. So, I mean, that's how the journey started. But eventually, since I wanted to become a lawyer all along, even then, so some of them had given autograph at that age, that hope you become a successful lawyer and all that. So the determination to become a lawyer was very much apparent. And then I, of course, finished my graduation in the Kirurimal College. And after finishing my Delhi Public School stint, and then the Campus Law Center, and 1982, my journey as a lawyer began.
Okay.
And of course, I started in Delhi, beginning. And then, unfortunately, a couple of years down the line, my father, Kishori Mohan Roy, he passed away. So there was a need for the family, for me to go back to Assam. So practically, even before I could actually set up my practice in Delhi, I mean, as in the learning process, while still in the learning process, I went off to Guwahati. And then the journey from Guwahati actually started in right earnest as a lawyer. And the lawyer journey was, of course, very interesting and exciting.
So you've served as a judge and Chief Justice of High Court as well. Was coming to Supreme Court always a part of the plan? Is something that you dreamt all along?
Srishti, in fact, I have always dreamt of becoming a lawyer.
Okay.
But becoming a judge was never in the agenda. And since you have asked me this specific question, I can tell you that when the first offer of judgeship was made, I firstly refused, of course, politely, and I resisted to say yes to the then Chief Justice. And I'll come to that story. And I'll tell you why I resisted. You see, when I went back to Guwahati, I started my practice. I was doing a lot of interesting works. Assam was a disturbed area at that point of time. So a lot of my work also had to do with pro bono work, meaning thereby people who were not able to afford lawyers, who were giving them free service. Anyway, a lot of that work was going on. And that point of time, some of those cases, they needed reporting to for the press. Now, they didn't have the papers in Guwahati, didn't have dedicated law journalists like you have nowadays, and as you are one. And so these reporters used to come, and since I was involved in many of those cases, they used to ask me for what the case is all about and what the issue is. Then one day, the editor of the Assam Tribune, may not be the editor, but somebody senior in the organization. The Assam Tribune is a very prestigious newspaper of Assam. He said, "Can you do our law reporting for us?" And since after Assam Tribune, the Press Trust of India, the PTI, they also. So I was the law correspondent for Assam Tribune and for PTI. And then because of this little bit of exposure, some of the media people were, becoming familiar with me. Doordarshan used to commission me for their, law-related programs and stuff. So that time I had the occasion to interview for Doordarshan viewers of Guwahati, eminent people when they were there in Guwahati, like Fali Nariman, Soli Sorabji. And, these were interesting times. And also I was, at that point of time, heading, while I was a lawyer, the Guwahati Music Society. So we were doing concerts and stuff. So very interesting time. And I had become a senior advocate. I mean, that's a very prestigious event for any life of any lawyer. I just become a senior advocate in 2004. So I was getting some interesting cases and some bit of money as well. And so when the offer came from the Chief Justice B. Sudarshan Reddy of the Guwahati High Court that I would like to consider you for judgeship. So I told him very politely, "Sir, I'm at a very interesting phase of my legal career. I would like to continue as a lawyer and may not like to opt for judgeship now." So, but he persisted, and and that was how perhaps. But why I said yes eventually is another story.
So, coming to your Supreme Court tenure, you have witnessed Supreme Court under the tenure of 6 different CJIs. Now,
I didn't count that. Okay.
6 different CJIs.
Yes.
Now, I won't ask you who was your favorite, but I will ask you whose tenure do you think, according to you, was the most impactful one? What made their tenure stand out from the rest?
Okay. You see, the first Chief Justice when I came was Justice Ranjan Gogoi, who was the Chief Justice. And Ranjan Gogoi happens to be a man from Assam. And coincidentally also, he was my, my mate in the chamber of my senior. My senior was one J.P. Bhattacharya.
Okay.
And everybody in that chamber, I mean, they went on to become, gain laurels in the profession. So, I mean, Ranjan Gogoi, Chief Justice Ranjan Gogoi was for me a dada, right? And so that was an interesting phase. Then the longest phase amongst the 6 Chief Justices that you are contemplating was, of course, with Chief Justice D.Y. Chandrachud. Now, D.Y. Chandrachud was my classmate in law college. So we are 4 of them. Yeah. Justice Sanjay Kaul, Dhananjay Chandrachud, Ravindra Bhatt, and myself. So he was like a friend. Although he was the Chief Justice, of course, on formal occasion, I'll, of course, address him as the Chief Justice. Yes. But in private, he would be Dhan to me and I'll be Rishi to him. Similarly is the situation with Sanjay Kaul, who was my batchmate again. So, since Dhananjay had the longest, nearly 2 years tenure during my 5.5 years in Delhi, perhaps that could be seen as a phase. But I must also mention about Justice Lalit, who again had a short stint, but I think a very impactful stint as a Chief Justice, because he did a lot of things which he, because of his special knowledge and experience as a senior counsel designated by the Supreme Court and as the advocate on record of the Supreme Court, he had a very good idea about how the Supreme Court functions and where there could be issues which can be addressed. So Justice Lalit also had a very good this thing. And then can we also sort of discount at all the wonderful stint of Justice Bobde, who was a very articulate, erudite judge, and he brought out those, the Courts of India volumes with so much effort, with bringing a good team of talented people together. So that again was this thing. Perhaps one disappointment with Justice Bobde's time was that we could not make any recommendations because they could not agree on the people proposed to be recommended. And then we have Justice Ramanna, Chief Justice Ramanna, who of course has this record of, inducting in one day 9 judges, including lady judges. That I think was a wonderful achievement and a cap on his feather.
Yeah. So the 4 batchmates three of your batchmates that you just mentioned, you're the last one to
the last
retire.
one to have demitted of that batch.
From Supreme Court. So, any plans post-retirement? Have you decided? Are you planning to continue in the legal field in some capacity?
You see, the life of a lawyer, and once you are into law, that never goes away. It remains with you because with years you gather your experience in law. Your exposure to law becomes widespread, in-depth. So a lawyer would always have some contribution to make. Now, my friend Justice Ravindra Bhatt is here in Delhi. My friend Justice Sanjay Kaul is here in Delhi. Justice Dhananjay Chandrachud, Chief Justice Dhananjay Chandrachud is also in Delhi currently after demitting office.
Yeah.
So I also have similar plans. Firstly, we have 2 daughters. Both the daughters are currently in Delhi. One is Kajri, who is a sports law. She practices in the field of sports law. The younger daughter, Sharati, she's just done her master's and hoping to go abroad for higher studies in maybe a year's time. Yeah. So the plan is to stay on in Delhi, but Delhi, as you know, is a very expensive place. So now that I have demitted office yesterday, we'll be looking for rental accommodation, and then hopefully we'll be able to. This house I'm able to retain officially for a month. Yes.
So talking about retirement, I think judges have often been criticized for taking post-retirement government jobs.
Yes.
The criticism being that it raises a question on the independence of judiciary, or that it creates an apprehension in minds of people that the pre-retirement judgment could have been influenced. Okay. What's your take on this?
That's an important question, and I think your viewers also need to be, clarified on this aspect.
Yes.
There are certain posts which are meant only for a retired judge. For instance, only a retired Chief Justice can be appointed, like for instance, the Human Rights Commission. And there are certain posts which can't be done by anybody else. So obviously that has to happen. But then it does create certain amount of, feeling that are the decisions given by that judge before he demits office influenced by what he might likely to hope for post his retirement. Now, speaking for myself, a specific query was made by the then Chief Justice Dhananjay Chandrachud asking, Hrishikesh, would you be interested for the kind of assignment that you are thinking of? And I politely declined. I basically told him that once I demit office, I would like to go back to being an ordinary person, a person with legal knowledge, but an ordinary person, not an office-holding person. And in recent times, in last couple of weeks earlier, somebody from the government at one of the highest position had also very specifically asked me requesting me to accept a government assignment, a very prestigious government assignment. of course, I also declined. But then he said that please reconsider and I'll come back to you in some days. Please give it a serious thought. And then the concerned senior bureaucrat in that ministry also came over in this very house. And then he again made a similar request. But I told him no. And I'll tell you why no. Because it is not that people accept it, so therefore there is a question mark. Not like that. But my plans are different. I don't want to be tied out to a government assignment. That's one of the key reasons. And then whatever position that you've held, now I've been a judge of High Court and Supreme Court combined for 19 years. So I would like to not remain in an official capacity for any longer time. 19 years, nearly 2 decades is a long time.
Yeah.
So, and if you have to start life as a private person, because no assignment is permanent, it is there for 3 years. So in any case, this journey I have to start 3 years later, even if I accept a government job. So that was my reason for, saying no. And then I would like to explore what other options are available for me. I have other interests and those I can very usefully explore in Delhi. So that is what my plans are.
So, as you just mentioned, interaction with government officials, my next question would be, do you think judges should maintain restraint in terms of their interaction, sitting judges, in terms of their interaction with members of the executive, considering not just the fact that you decide their cases in court, but also in a way you're expected to keep a check on the executive. Now, this discussion once again came to the fore recently when we saw the Prime Minister visit the then CJI D.Y. Chandrachud's residence for a puja. There was a lot of debate and discussion around it as to whether something like that should be done or should not be done. What's your take on this?
You see, we have what is called the Bangalore principle of judicial proper behavior,
yeah.
etc. Right? Now, normally judges, they never interact with people in power, except maybe in an official function. If there's a law day function or a constitution day function,
yes,
the political functionaries would come and they will of course share the stage. But beyond that, nothing. Perhaps Chief Justice's position is a little different as compared to other judges because he also has the institutional responsibility on his shoulder. So very often, maybe infrastructural issue or appointment issues, he has to interact. So that is given. But for people to understand that these interactions happen, there are places and there are procedure through which these interactions do happen. For the Chief Justice, I am saying particularly. And the specific incident that you have mentioned, see, it was a private function of the Chief Justice, then Chief Justice, and of course the optics look a little disturbing. But I would think in hindsight it could have been avoided if it was a private function. If it would have remained just the two gentlemen meeting in that puja room without media camera focusing on that event, I think everything would have been all right. But here, I think because it went out of the puja room, away from the puja room to the public gaze, I think that had created the difficulty. But I'm very confident that neither of the two would have discussed any court-related affairs or anything. There would be any attempt made to influence the decision of the judge concerned. They are absolutely, just Chief Justice Chandrachud is an absolutely man of integrity, and I have no hesitation to say that and I firmly believe that there would have been no occasion for him to discuss with the Prime Minister any court-related affair on that meeting.
So talking about the criticism of judiciary, we've often seen that the role of the judiciary has often come under scrutiny, where we've seen criticism in terms of certain judgments where it's seen as an arm of the government. On the other hand, we also see that judges, it's said that when in lectures or during hearings, we often see judges talk about the importance of liberty, secularism, etc. But when there are certain cases when those cases come before them in a courtroom, when push comes to play, at times they fall short, like the court has fallen short to deliver. What is your response to these criticism as far as the judiciary is concerned?
I certainly would not like to comment on individual cases.
Yeah.
But I do believe, the perceptions may differ, but I do believe that when a judge is seated in a court, either in the High Court or in the Supreme Court, his primary concern is to do justice in a given case and also to do justice in accordance with law. Now, very often an image is created that so-and-so, the liberty aspect of X is not being addressed well by the court. Now, there are laws which prohibits consideration. We don't have to name statutes which says that unless the court is of a prima facie opinion that it is unlikely to result in conviction, bail should not be given. Now, the lawmaking power is with the legislature, as you know.
Yeah.
And the court has to interpret those provisions and then apply it to facts of a given case. Now, suppose the law is, crafted or drafted in that fashion, it becomes difficult. But even in those cases, for instance, a law which requires the court to come to a conclusion before considering bail that whether he is guilty or not, and court should consider bail only if it is of a prima facie opinion that he is unlikely to be guilty, the courts, and you would notice, and as an observer, you will notice them more, is that courts have said that, look, you can't have a person incarcerated in jail for prolonged period. I mean, that affects his liberty guaranteed by our constitution under Article 21 and so many other provisions. So therefore, court have risen to the occasion. Only thing is that whether the law and the constitutional norms applied in a given case, that the judge has to test. And very often, more often than not, the judge actually discharges the responsibility of upholding the liberty of an individual. But there could be one or two cases where people might find that to be of a little aberrative. But I think those are exceptions, and we can't be criticizing the courts and the judges by those aberrative decisions.
So, but do you think the bail jurisprudence is being handled properly in this country, right from lower courts to top courts? Because we've seen many retired Supreme Court judges who've also come out and spoken about the fact that despite the top court reiterating again and again that bail is the rule and jail is the exception, that seems to not be percolating to the trial courts.
To some extent, your comments are right. We have, and as judges of the Superior Court, whenever there are occasions for us to interact with judicial officers lower down the line, we have always reiterated, particularly the Chief Justices have been very vocal about that. I've attended many conferences where, the Chief Justice or I myself had attended and organized events where, as judges of the High Courts and the Supreme Court, we have said that bail should be the norm. In fact, practically, we would all think that, all bail matters should end at the stage of the High Court, should not come to the Supreme Court. But then we are increasingly seeing bail matters also being pushed to the Supreme Court. One of the reasons is that some of the, these accused are, rich people, powerful people, have access to good lawyers, so they would try their utmost right up till the final court. And the other is, of course, are cases where, the accused is backed by people, who might be, trying to push it. And then sometimes they also feel that, look, in this case, the man or the woman did not get bail in the CJM's court, in the Sessions Court, and in the High Court, but he or she got bail in the Supreme Court. So those are the examples which, encourages people to come right up to the Supreme Court. And whenever such infraction is noticed and that where bail is deserved and is not granted, I'm sure all of us, including myself, we have uphold the right and liberty of an individual, that he should not be kept behind bars for too long, unless there are good reasons to keep him behind bars. Yeah. So I suppose there can be a perceptional difference, but I think by and large the court has been upholding the liberty and the right of an individual.
Okay. So coming to the system of appointment of judges, yes. Again, one question that we often ask judges who've retired, especially those who've been part of the Collegium, yes. to get your insight into it. Yes. there's been constant debate around the Collegium system, which is the present system for appointment of judges to High Court and Supreme Court. Again, criticism on the lines of lack of transparency, the fact that judges are appointing judges, and if that is something that should be done. According to you, do you think the current system as it stands is the best system that there is for appointing judges? Do you think there are some improvements that are required, or is there a completely different system altogether which should be put in place?
Okay, to react to your question, I would firstly say straight upfront that the system that is prevalent there, we don't have an alternative system which is better than this. So I'll say that this is the good system.
Good system.
But then you are also asked how we can also improve the system.
Yes.
Now here, let me share my experience as the Chief Justice of the Kerala High Court. Now, you would, of course, appreciate that although there is a collegium, the senior judges the Chief Justice and the senior judges as a collegium, they decide on the appointment and recommendation. Chief Justice has a major role. Now here I am talking about the Chief Justice of a High Court. Now, under our current dispensation, you can't become a Chief Justice of your own parent High Court. My parent High Court was Guwahati High Court, so I could become Chief Justice not of Guwahati High Court unless I had a few months tenure. Those are the exceptions. So I became Chief Justice in Kerala High Court. Now, when you go to a new High Court, it is obvious the new Chief Justice would have no clue apart from the lawyers who are regularly appearing in the Chief Justice's court on their capability and qualities. And yet, the Chief Justice has to make a conscious decision, along with his senior colleagues, of course, to recommend the best. Now, how does one do that? Now, this troubled me as I was holding the position of Chief Justice of Kerala. So what I decided and what I did is what I'm sharing with you. I decided to write to all my judge colleagues, women or men judges, saying that we have this many vacancies, which we as Collegium propose to consider. Now, I would request each one of you to shortlist, say, twice the number of vacancies that we have from amongst the lawyers in Kerala, and then send this information to me. Now, in the Chief Justice's confidential cell, we received all the letters. Now, for instance, say there are 30 judges who have responded. Now, there will be, let us say, 5 names which will be common in all the judges list. So they are obviously the preferred choice of all the 30 judges of the High Court. Then there could be, let us say, 4 names which are finding place in the recommendation list of all the 30 judges. Then similarly 3 names, 2 names, like that. So eventually we collated this information and we collected, all right, A has received, say, 6 nominations. Or not 6 nominations, say 25 nominations. B has received, say, 23 nominations, like that, down the line. And then, of course, a lot of these names were totally unfamiliar to me as the Chief Justice. So what I did was, I got the information of the cases in which these lawyers were appearing, arranged for getting their cases listed in the Chief Justice's court. So in my court, suddenly lawyers are very puzzled to see that suppose I deal with a certain roster, certain subjects, then they were finding that in Chief Justice's court, other subject matters were also getting listed. Of course, they caught on what was happening. So the lawyers who had cases, but whose cases are not normally part of the Chief Justice's roster, their cases were listed in my court. Of course, I was sitting with a colleague, a judge colleague of the Kerala High Court. And then we listened to those arguments in those cases, and I could firsthand have a understanding and estimate the capability of the individual concerned. As it is, I had the names given by my colleagues. Now, obviously, the person who has 25 nominations, his name is being considered or her name is being considered. So I personally could visualize how good that person is in her or his presentation as a lawyer. So that's how we shortlisted. So you can well understand that here there is no element of any opacity or no, there's a very healthy process, I thought, and I could achieve good results because eventually when we made the recommendation, or rather when I moved from Kerala High Court as Chief Justice from Kerala High Court to the Supreme Court, I was happy to share with your viewers that all the vacancies in the Kerala High Court either were filled or recommendation for the remaining vacancies were in the pipeline. So I left Kerala High Court to the degree of satisfaction. Yeah. And my colleagues later on said that the shortlisted names that I, as the presiding of the Collegium member of Kerala, those are very, very, very fine names. I mean, they got recommended only on basis of merit and no other consideration.
So, do the Supreme Court Collegium judges who are there in the Collegium, at least till the time you were a part of the Collegium, ever have this a point of conversation where what are the changes that are needed to be made, or what are the changes, any changes that they've decided to make in the already existing procedure?
Yes, I think whenever the Chief Justice and the members of the Collegium, they meet with a specific, this particular agenda, certainly this discussion happens. And this discussion may happen even when they meet, not necessarily as a Collegium agenda related meeting. Informally also they may discuss. Just to give an example, 4 or 5 years back, there was a practice, I think it could be 6 years back, there was a practice of the recommended persons from the High Court being called to Delhi and being interviewed in the Supreme Court before their recommendation is made. Now, that practice down the line was given up for whatever reason. But recently, our current Chief Justice Sanjeev Khanna, he decided to reintroduce the concept of, interviewing or rather at least interaction with the nominees. Yeah. So recently, you might know that there was a retreat for the judges in Visakhapatnam. And there, in the neighboring districts, neighboring states, the judges, rather lawyers who were recommended by the High Court Collegium, they were all requested to come to Visakhapatnam. And there was interaction by the Collegium judges, senior Collegium judges, and the Chief Justice. And then, so this is something which was abandoned 4 or 5 years back and again restarted. So there is a constant thinking about how best we can go ahead with the process of selection and make it a selection which is, sometimes aberrations do happen, but to the extent possible to ensure that the best is selected and the deserving one is selected.
So as you just mentioned about how there's interaction of judges, candidates,
yes,
there, which has started again. This need for that was also recently discussed and stressed upon a lot when we saw some remarks that had come in from a sitting Allahabad High Court judge. You're part of the Collegium that he, as reported, was he interacted with. What is your take, firstly, on the remarks, considering those remarks came in from a sitting judge? And a follow-up to that would be the action that was eventually taken on that. Do you think that is enough? Because it's instances like these which may have an impact on the citizens and how they see the judiciary and their faith in the judiciary. So the question that it raises are there absolutely no restrictions on such statements which are made by judges?
Srishti, just a while back, I mentioned about the Bangalore principle to be followed by all the judges. Now, I mean, this is true. Only when aberration happens, they get highlighted, right? Now you have, let us say, 1,000 High Court judges, a little less than 1,000, and 32 or 33 Supreme Court judges. Now, these many number of judges are functioning without any fingers being raised. But say there is an aberration vis-a-vis Judge X or Judge Y, that of course gets highlighted, right? Now, obviously the selection process is such that you try to choose the best, but eventually how a particular person will behave down the line, 2 years down the line, 3 years down the line, perhaps that is the prerogative of the Almighty. But whenever these kind of things happen, we are always confronted with the situation that the judges in the higher judiciary are supposed to, take decision without fear or favor. Now, to facilitate a judge to take decision in this fashion independently, a lot of protection under the constitution and the laws are given to the judge so that he need not be scared of anybody. He need not be sort of looking for some favor from anybody, and he is capable of taking independent decision. Now, this particular protective shield that is available for judge for a more lofty purpose for him to work as an independent judge comes in the aid of also the Judge X or Judge Y who might have, demonstrated some aberrative behavior.
Yeah.
So my take here is that the system that we have is more towards protection, and protection not of the not so good ones, but for all the judges. And that also helps the persons who may not be towing the line as it is supposed to be towed under the Bangalore principle.
Yeah.
And my feeling is that we have the system of impeachment, we have the system of inquiries, but these are not adequate measure. Our law doesn't provide for adequate measure for taking action. You can do nominal things like, say, taking away the casework from a judge, but he or she might be happy to just sit at home and earn his salary. You might transfer him from one high court to another, but that I have a very strong issue, because very often you see a judge who is not sort of perceived to be a good judge in a high court A, he is being transferred to another high court. And very often, I come from Northeast, very often such judges are transferred to Northeast. I think this is a very wrong way of dealing with the matter, because if a judge is bad in place A, maybe he will not remain bad in place B, but then where he is transferred, that court is bound to feel that if some judge is not good enough for that particular court, why should he be considered good enough for my court by transferring him? And particularly if a judge continues to behave badly in the transferred court as well, if he is transferred to a smaller court, the capability to cause harm is magnified. Suppose it is a small high court, we have smaller high courts where only 3 judges are there. Suppose one of the 3 is not a good judge. So 1/3 of the judges, output is not a good output. It's a negative kind of thing. So I think if you have to transfer, I think the transfer policy should be that you should not transfer him to a very small high court. You must transfer such judges, if the need arise, to a court where he is capable of committing least damage. That is what I would feel.
So as far as Justice Yadav's case is concerned, was any action taken by the Collegium after it took cognizance of because that was the only official communication that was made on behalf of the Supreme Court?
You see, in terms of action, like I said, we have a protective shield for the judges, right? Now, of course, the media, it's a well-reported thing that the judge concerned, when this particular thing was made, without actually commenting on an individual case, he did come and met the Collegium members, and then there was an interaction, and the judge did said sorry and apologized in that meeting, and he agreed also to apologize to all the 5 of us who were sitting there in that meeting, But it was insisted that the apology cannot be confined to this particular room where 5 of us were sitting with the judge. It must be given in a public forum so that people know that he's apologized. And when the meeting ended, the concerned judge, he left the meeting with the assurance that yes, the apology in a public, whenever the opportunity comes, would be made in a public way. But after few days, we came to know that the apology is not forthcoming. Okay. So thereafter, an inquiry is ordered. That process is currently on. Okay. And but as I said, we don't have a adequate mechanism to deal with aberrative behavior of judges of higher judiciary.
So, if his speech, in his speeches, he'd also spoken about UCC, which takes me to my next question. We recently saw Uttarakhand become the first state to implement the uniform civil courts. What's your take on implementation of UCC in India, especially considering the existing laws and the constitutional and the social fabric that exists as of now?
You see, whenever any new legislation comes into being, the one you mentioned or any other, now, if they're tested on the constitutional viability, the concerned court will answer that constitutionally whether it is valid or not. But otherwise, it is a policy decision of the government and the legislative wing. Now, whether a particular law is to be implemented or not to be implemented is a legislative decision. Now, whether it is a valid decision or it's an invalid or it is conforms to the constitutional norms is a decision which is in the domain of the court.
Yeah.
So beyond that, I would not like to say, because whenever it is tested, I'm sure the concerned court will answer that.
Okay. So we've often heard in courtrooms, I've personally reported from courts. So we often hear judges ask lawyers to not bring politics into court. But politics in a way has reached courts, because if we see the number of cases that are being filed against political leaders in the last few years has increased, be it allegations of scam, be it defamation cases. Your bench, you've also recently in the last few months, you've heard a few of those cases where you've granted bail in one, in a case related to the Delhi liquor policy case. You also passed an interim order in a defamation case against the current and the former Delhi Chief Minister. Now, opposition leaders have time and again claimed that the laws are often used as a tool against them. My question to you, sir, is, do you think the judiciary in the position that it is in today, is it in that position where it's doing enough to ensure that investigating agencies or laws, statutes are not used as a tool in the political field or as a tool to stifle dissent?
This question, in order to answer that, one has to have multiple issues to be considered. The first thing is undoubtedly we are seeing instances of the government in power using the legal machineries to target individuals in opposition. The courts, whenever the situation demanded, had intervened and passed restraint orders. But then the more important thing is, no government in a democracy can say that I'll remain in power forever. We have had, governments since our independence. There have been change of governments. So therefore, I think it is in the interest of each government to ensure that judiciary is impartial and independent. Because if you think that today the people in the opposition are having to move to the court for their liberty issues and any other persecution issues, tomorrow if the current dispensation is not the ruling party, they will also have similar, issues to be taken to the court. So therefore, it is in the interest of all parties, irrespective of their political ideologies and views, to ensure that we have a vibrant and functioning judiciary, which we have in India. But they must not do anything to undermine the pristine and the purity of judiciary. I think that would be in their interest also. So we've had, several instances, where the people who are now in the opposition were in the ruling dispensation. And that time, those who are currently in the political ruling arena, they were the ones who had to take recourse to the court process. So therefore, I think that realization and the maturity is expected of people who are in power.
Is there political pressure or government pressure on judges? Is that something that you have faced or you've seen judges face during your time?
Not at all. Not at all. I would think that there have been occasions in a formal meeting, for instance, I was in Guwahati. My parent high court is in Guwahati. There was a Diamond Jubilee celebration of Guwahati, where all the political bigwigs of the northeastern states and also from the Prime Minister and the Law Minister, we are all sharing stage and we are all having interactions. I mean, those are the times when you are freely talking with this thing. I mean, there may be so many issues that you might speak about, but at least in my experience, none of the political this thing would come and say that here is this matter which is going on, Justice Roy. Can you help us with that? There has been no such occasion. And so I feel that this must be the experience of my sister and brother judges in the country.
Okay. So you had passed a very important order in the Kawad Yatra case where we saw you staying as on the very first hearing, you would state some directives which mandated names of shop owners to be published on the route of the Yatra. Now, so it's true that religion is a very sensitive issue. We also know that there are many cases which are pending before courts where different religious communities or parties are involved, issues relating to those religions. Is there an added pressure when you're handling cases of these nature?
The specific case that you mentioned, no, it is like any other case, but the added pressure element that you are talking about is that this particular yatra is, it lasts only for a few weeks. So in a normal process, the court issues notice, then there's a response received, and thereafter some order, if it is to be passed, is considered by the court. Now, this was not a case here. Now, suppose legally the yatra was not appropriate. And here you must also be conscious of the fact that they issued the order in a very cryptic fashion without actually indicating under what provision of law the order is being issued, directing the shopkeepers to display their names, etc.
Yeah.
So the legal issue was very clear that these directions were perhaps without any authority of law, or at least demonstrated authority of law on the face of it. Now, suppose in a case of this nature, suppose you say, all right, issue notice, returnable in, let us say, after a week, and then thereafter response comes. By that time, the yatra itself gets over. So in a case like this, I'm talking about these specific issues and similar such cases, the idea is to give a little longer hearing for the court also to assess the strength of the case, whether it is supported, and then reach a prima facie conclusion whether an ad interim order would be necessary. So, and then more importantly, if you are passing an order, to indicate the reasons why you have passed the order. Now, in Supreme Court, as you might know, one can simply say, all right, issue notice, interim order. These words are enough for the Supreme Court order to be valid. But I had this habit of, writing out the reasons whenever I pass an interim order. And I think in the case that you are talking about, I think I passed a fairly detailed order indicating why I am passing the order. So I suppose that is to indicate the state of mind in which I passed the order and what are the legal reasons why such an order I found to be justified.
So because these cases also we've seen have increased a lot, be it cases related to places of worship, mandir masjid disputes, all of these. When I asked you that question, I think at times even lawyers around me who I've seen interact, even laymen, people who are not from the legal profession at all, I've seen them wonder and discuss that when you hear cases of these natures, because we all belong from a particular community or we all have a certain ideology, are these cases more difficult than any other case that you would decide? Because at the end of the day, there are religious sentiments of people involved.
You see, as judges, we take oath to uphold the Constitution. Now, our Constitution professes independence. Our Constitution professes independent of practice, faith, religion, etc. So when we take oath to uphold the Constitution, obviously we are expected as judges to sort of do everything which will not undermine the guarantees that are given by the Constitution. You are right in saying that these kind of matters are increasingly visiting the courts. Now, the only reason one can fathom is that, these, say you are a person in the media, the focus of the media in these kind of cases are far greater than the ordinary common criminal cases. And the net result is that the kind of publicity that is generated, not even at the stage when the case is being considered by the court, but even at the stage when it is being filed, there's enough media coverage of a litigation of that kind. So for the person who is doing it with a purpose, his job gets done just by the fact that he's filed the case. Now, eventually, whether he gets relief or she gets relief is not a material concern for him, because, as if we're in politics, even bad news is good news. You have to be in the news, even if it is not so positive news. So sometimes they think like that. But the courts, by and large, have been fairly vigilant about this kind of publicity-oriented cases, if I may say so, and have nipped it in the bud, or even if it has gone through the initial judicial scrutiny, to have closed it at the end. I think the courts are vigilant enough, and they do a fairly good job. I would believe. And for instance, where interim order is justified, court passes an interim order. Where the case has to be dismissed, court dismisses such a petition.
So even though social media interactions have increased a lot drastically in the last few years, how do you think judiciary or the judges in any way are impacted by what happens in social media? Because we see not just criticism but also trolling, where judges are trolled for in their personal capacity for the judgments that they pass. What's your take on this?
You see, now social media is a platform where the most ignorant can also pass a comment. Somebody who is educated in law can also pass a comment. So therefore, if you give too much importance to what is percolating and circulating in social media, you are bound to get distracted. But I feel that our judges are mature enough. Of course, somebody who just joined at the entry level may have little difficulties. But as we go along in the judgeship, we become mature enough and confident enough to handle the case on its own merit, rather than being influenced by what is circulating in the social media.
So obviously your judgments aside, you're also known as a judge with a great sense of humor, something that I've personally also witnessed while covering courts during the court hearings, for your wit, for your humor. Do you think a certain sense of humor is needed inside a courtroom, which is an otherwise very stressful stressful kind of an environment that we see in courtrooms? Do you think a certain amount of humor, light-hearted moments, conversations are good and will actually benefit, especially young lawyers who appear before courts?
I absolutely say yes to your question. There are straightforward reasons for that. You see, this may not matter at all for a seasoned lawyer, who is not concerned about the atmosphere in the court, even if it is intimidating or such as. He's gone beyond all that. So he will present his case or her case irrespective of whatever the situation in the court is. But look at the young lawyer. If she is arguing a matter, let us say a fairly heavy matter, the weight of the matter itself is weighing heavy on her mind. And it's an intellectual exercise, and you are making your arguments in a court of law with a very heavy matter. Your years in bar are not so long that you are not concerned with what is going on. So suppose if I were to lighten the environment, I think after all what the court is expecting, so that the lawyer is able to present her case in an efficient and effective manner. Now, if by lightening the mood in the court with an element of humor, you are putting the lawyer at ease, for what purpose? To get the best out of her. So I think there has to be a yes to the question that you posed. And then very often I have got compliments from the legal fraternity on this. And I feel that as a judge of a superior court, the Supreme Court or in the High Court, that's the little you can do to encourage the younger people who are the future leaders of the court. You see, you are in an apex position today, but then who is just starting out in life today in law, he or she is the future leader. So if you sort of facilitate their growth, I suppose it is good for the institution.
So, I actually spoke to a friend of mine before this, while I was preparing for this interview, somebody who's not a lawyer, who's not from the field at all, just trying to understand what is it that a person who's not from the profession, what would that person want to ask a Supreme Court judge? So I asked her, I was like, if you could ask a question to a Supreme Court judge, what would it be? And what she said would be my question to you. She said that do judges ever find themselves in a situation where, she called it dharm sankat, where there's a moral ethical dilemma between facts, the law, the facts that there are, or the law that you need to, like law says a certain thing versus your conscience. Is there any case that you can remember where something like that has happened with you?
It may not happen very often, but I am sure in judges' life, you would be confronted with the situation like that. In a case like that, the only way you can sort of try and answer is to look what is the provision of law, or what does what would the Constitution dictate? Is your conscience being guided by what is tugging at your heartstrings, or what should be the right thing as per the constitutional norms and morals? Maybe it takes a little while to get an answer of this kind that might be troubling the judge. But then maybe you will spend that extra minute or two to sort of search within yourself. And then whatever is found to be constitutionally valid will eventually be answered.
Okay.
And we think when we answer it that perhaps constitutionally this is the correct, and justice of this case will be made by this answer. But sometimes the justice of a case, which as a human being you might find is in a particular decision, that may not be supported by the constitutional norms. In that case, somebody might perceive that here an injustice is done, but the law does not permit you to sort of this thing. So occasions you might be able to mold the relief, but there could be occasions you may not be able to mold the relief. So that is a dilemma which is constant.
So considering I was interviewing a judge who's known for his wit and humor, I decided to keep a very short segment of this interview with just a few quick questions. We could call it a rapid fire of some sort. So I'll just start off with my questions. First, your favorite colleague judge in Supreme Court, someone you enjoyed sharing the bench with the most?
Well, when I sat with the Chief Justice, that's very enriching experience.
Okay.
Sitting with Justice Sister Nagratna was again a very enriching experience. I've had also the opportunity to sit earlier with Justice Bobde, Chief Justice then, was also very enlightening experience. So, but experience would be different with different judges.
Okay.
It's not a thing that is universal or uniform.
So your closest friend from the Supreme Court bench, judges right now, all the judges?
You can count all of them. I get along with a lot of them together.
Okay.
But we had recently Justice Sanjay Kumar, who has come in not too long ago. He's from Hyderabad. A very dear person, and his wife Swati. So I would consider them to be fairly close, like my younger brother. But this would be also true. I mean, Sister Nagratna, such a lovely person. Justice Bela Trivedi, these are the two sisters that we have in the Supreme Court. And Justice Sanjeev Khanna, the Chief Justice, he is a little reserved person if you compare him with the earlier Chief Justice, Dhananjay Chandrachud, but very strong in the fundamentals. So I've had occasion to sit with them, and particularly the ceremonial bench, and earlier also with Justice Sanjeev Khanna. So they are people with great deal of sagacity, great deal of knowledge and expertise, and also wisdom. So these have been very enlightening and good experience.
So your favorite movie or TV show that you enjoy watching?
TV show, none. I don't have any time for TV show.
Then movie.
But movie, yes, there would be, say My Cousin Vinny. I don't know, it must be well above your time, but it has to do with a criminal trial. So My Cousin Vinny is a good thriller. Then Witness for the Prosecution is another one. Then Ek Ruka Hua Faisala is another one that's based on the 12 Angry Men, story. And then if you go into the thriller genre, there would be others. So there would be a lot of movies.
So we at times see some cricketers sing, when they're under pressure on field. What's your go-to activity when you're stressed?
I try not to take too much stress upon myself, but I enjoy reading. I mean, reading has been a constant hobby of mine. So at any given point of time, I am going along with a couple of books. So reading is a very stress buster thing for me. I enjoy theatre. So occasionally one also indulges in the Mandi House circuit, the Kamani Auditorium, the Shriram Center, or the National School of Drama.
Yes.
In fact, currently I have the list of the theatre festival, National School of Drama that is being organized. Multiple plays are there. I hope to catch up on a few of them.
So if there was one thing you could change about the top court or judiciary, what would it be?
I would want more women to be judges. And I think we are making progress in that direction. I mean, you may not see the results right away, but a lot of women are taking up the legal profession. A lot of them are getting selected in the district level judiciary. Eventually, they will come to High Court and then they will come to the Supreme Court. So there is a larger group of people to choose from. This is one thing. And another thing is that this virtual mode of, making arguments, I think is facilitating a lot of women because it is basically an intellectual profession. So women are now going to make a far bigger mark. And I hope that, it happens.
So the most fulfilling and the most challenging case for you till now?
You see, it's not, a case cannot be fulfilling or a challenging, and each case has its own challenge. But how you sort of work the judgment is something which might give you a bit of a satisfaction. Now, there was this case pertaining to the National Green Tribunal. The issue before us as a Supreme Court judges was whether the National Green Tribunal can entertain a case without an petition or application being filed. So I referred to the two protagonists in the play Waiting for Godot, and they were all waiting whether Godot will ever come or not. So starting the judgment with these two lines of Waiting for Godot of the two protagonists, I said that the National Green Tribunal should not be waiting for a petition to be filed, and if there is a cause which demands, they should suo moto, and they can take suo moto action. So that was one case which I can identify for you. Ankita Sinha.
Yes, sir. So last question, one advice to your young lawyers who are watching you.
Young lawyers, you see, I always say that, hard work, commitment, etc., these are all absolutely essential things. But sometimes people in course of the early stage of their career, they might suffer setbacks, but then you should not be swayed by that. They might also see success of others which they are not getting at that particular level. Now, every career will have its own trajectory. So therefore, first and foremost, you must remain committed, you must remain rooted, and you must have an ethical practice. Only then the recognition will come, because the judges with their experience can clearly identify somebody who is not speaking the truth, somebody who is not trying to assist the court as it should be. So that should be avoided. You must always make sure that whatever you are saying is correct as far as your understanding of law, and then put in the hard work and recognition will come. So I would expect the young lawyers to follow. And I think that's the only way to sort of grow in the profession.
So concluding, I would like to say in many cases we've seen that when the orders were dictated, after the order was dictated, the last word was often yours, where you would end the hearing with a fun remark. That is something I would like to do today as well. So I would request to you if you could end this interview with a remark, something in your your style.
Srishti, it's a very interesting conversation that we've had, and I thought that I'll make an attempt to sort of highlight my positive traits, and if I have succeeded in doing so, I would consider that the interview is done well as far as I'm concerned. I don't know whether it is the same experience for you or not.
It definitely was. Thank you so much for speaking to us, sir. That was Justice Hrishikesh Roy speaking candidly to India Today. Please keep watching India Today for more updates. Thank you.